Okay. Obligatory disclaimer, and I'm very sensitive to this. This is not legal advice. I am not a lawyer. It's very dangerous to give legal advice if you're not a lawyer. So this is not legal advice. This is simply, as I put up here, advice that I would give to any friend practicing in the industry based on my own experience. Since I've been working as an expert witness for 20 years now, 20 years this summer, I have had a chance to see a lot of IT workers who got sucked up into lawsuits. Usually it's not individual lawsuits, so I have seen individual lawsuits. And individual lawsuits for some of the issues that we'll talk about here. But these are things that you need to be aware of because they're the sorts of things that you don't think will matter until you get a subpoena. or worse yet, have a lawsuit delivered for you. 6 areas of caution. First, unauthorized access. Poking, we're geeks. You want to poke around where you're not supposed to poke around. And you may not know you're not supposed to poke around. Turns out there are some real legal pitfalls here. So unauthorized access. Intellectual property, copying stuff you don't have a right to copy. Doing your own projects while having a full-time job. Non-compete restrictions from your employers. Troubled or failed IT projects. And the need for preservation of documents in the event of litigation. Back in 1986, Congress, in its infinite wisdom, and I'll just say for the record, Congress always gets technology legislation wrong. Oh man, they just do. They just cause more problems. But they passed this thing called the Computer Fraud and Abuse Act that originally was set up to allow for some civil penalties for, sort of civil penalties against hackers. We need to protect against unauthorized incursion. Since then, it has morphed into something that can apply both civil and criminal penalties for anyone who is judged to somehow have gone into a system somewhere or done something and the alleged plaintiff can claim it was unauthorized. It's very broad, very vague, does not define what without authorization means. There are no statutory limits. Very harsh penalties. How many of you know who Aaron Schwartz is? A few of you. Aaron felt that the paywalling of academic papers was wrong, took it upon himself, set up a server, and he had access through a paywall, was downloading academic papers there and making these broadly available. He was basically violating copyright and some other things. He was found out, and instead of getting his hand slapped or being prohibited or so on, the DA threatened him with 35 years in prison for having done this. His crime was literally making academic papers available. He was threatened with 35 years in prison. He committed suicide. The point is that DAs like to find stuff where there's stuff to find. They like to use heavy threats. Yes?
Have you ever heard of the story of the BYU professor that got into trouble?
No, I haven't. Would you tell us the story?
Yeah, so I heard from Dr. Clement, I can't remember the name of the guy, I probably shouldn't say it anyways, but...
No, probably not.
Yeah, he was a BYU professor here, and then he went and got a government job in the state of Utah. And he was doing some kind of pen testing then, and they said that he wasn't really great at playing politics in a government role, and he wound up getting fired. And one day, he decided to see if the people of the state of Utah ever decided to implement his recommended security changes. For all the pen testing that he did a little pen testing of his own, unemployed. And apparently they threw the book at him, and he's still in jail. I think he's in jail for the rest of his life almost.
Yeah. And that's the problem, is that you have this sort of thing. Now, is it a temptation? Yeah, it is. I worked at the Lunar Planetary Institute. That was a cushy job in Houston that I'd probably still be at. I mean, I got 5 weeks vacation a year. I worked with space scientists. But I left there and moved back to San Diego. But I had been, besides being a programmer analyst there, I'd also been assistant system administrator. And actually, for a couple of years thereafter, I would every now and then call, because they had a modem on a phone line. I needed the phone number. I had all the passwords. I'd call in and just go poking around the network and see who was doing what. It was never malicious. It was just sort of like going back and walking through the building again, equivalent. You know, when it's kind of like you leave a job and you still have your keys and you go back and, oh yeah, let's go walk through the building. And I lacked authorization, but you know, I'm not sure anyone ever knew I was there. But the point is there are things that may seem harmless to you that can have some very have very serious real-world consequences.
You're saying don't do that.
Don't do that. I'm saying don't do that. I would not do that today. I was young and naive back then. And I was actually before the CSAA. Yes?
You probably know more about this than I do, but there was a mayor, or someone running for mayor of Provo some years ago, and he ran under, one of his claims was that he was a graduate of BYU, and so he was familiar with the local populace and the whole experience. Someone at the BYU IT building took it upon themselves to find out if he really was a BYU graduate, and they have access to that kind of information. And so he did some searches, and lo and behold, the person actually was not a BYU graduate, leaked that to the press, and they had a heyday on it. I think he still ended up winning the election, but the person at the IT building was found out and fired.
Oh yeah, yeah. Again, you may have great noble reasons for doing this. Let me tell you, in the real world, it's a lot nastier. And of course, none of this is addressing what this was really meant to address, which is you see stories on a regular basis if you're in the trade industry. There's a famous one, and I believe it was for the city of San Francisco. Their system administrator was unhappy with a lot of things, and they ended up firing him, and he planted some logic bombs to go through and wipe out files and do other stuff, and got sent to prison for it. You know, the point is just be very careful where you go and what you do. Don't think it's harmless. Don't think no one will find out. Security is still a big issue, but there are a lot better tools for monitoring security now, so don't think that you're not going to be discovered. Intellectual property, 4 key areas: licensing, copyright, trade secret, and patent. Licensing is what happens when you buy a piece of software. You're almost always licensing it. And of course, how many of us click on a EULA without ever reading it? Yeah. Started reading those, yeah. Actually, I just saw a news article from a company, it was a software company, that down near the very end of the EULA had buried a paragraph.
So you get $8 grand or something.
Yeah, they basically offering money. If you read this paragraph, the first one to respond to us who's actually read this paragraph, we're going to give you cash. And someone finally read it, but it took months before anyone actually read that far. Copyright is a right to creative work. I could give a whole lecture on copyright. I do a lot of software copyright cases. This is why you can't leave a company and walk off with their source code. They almost certainly have the copyright to it, unless you've got some explicit disclaimer to the other thing that you own it. Yes?
Don't you need source code don't you need both sources to figure out copyright?
Yes, generally speaking, though there is a whole methodology for non-literal copyright infringement, because what happens if I take a program in C and rewrite it in, say, Swift? Does that somehow obliviate the copyright of the program in C? The answer is no. There's a methodology called abstraction, filtration, comparison, allows you for non-literal copying source code. And that's a whole field in software copyright. So yes, you need to do comparisons, and I've done those comparisons. I had a case where Speaking of walking away with stuff and so on, here's a case. And if I've already mentioned this, just someone stop me. Had a small software company that was doing database management software for IBM's DB2 database. Big company, Computer Associates, came in to buy up the small company. 5 of the programmers there did not want to work for Computer Associates, so they all quit and went to another company, Quest, not the telecom, Q-U-E-S-T in this case, to work on IBM DB2 database tools there. Unbeknownst to Quest, one of the programmers came across with a CD-ROM of source code for what they've been working on in the company. One of those 5 programmers, fast forward a year or two, one of those five programmers doesn't get the raise he expects. So he quits Quest and writes an anonymous letter to Computer Associates that says, Quest has your source code and they're using it. This results in an immediate lawsuit by Computer Associates against Quest. Quest approaches me and says, here's a lawsuit. Here's what we found out. Yeah, it turns out that, we have acknowledgement from one of these 4 remaining programmers that yes, indeed, he brought over source code. We need you to see if it's actually in our shipping code. Problem is, I'm looking at 5 million lines of source code on one body and 3 million on the other. So I write some tools to do fuzzy matching. In other words, I'm looking for identifiers that have substrings in them that match, lines of code that mostly match. I literally go out and buy 2 new PCs. This is around 2002, 2003. And for 2 weeks, I have 3 PCs running 24/7, doing what ended up being a total of 5 or 15 trillion line-to-line combination or comparisons. And sure enough, actually what I find, what triggers it, I find a number of similarities. Some of them turn out to be third-party code. Some of them turn out to be code that one of the programmers had developed, tools he developed on his own before he came to the first company, and so could say, I have problems with that. But the big red flag was there was a section of code, it was actually the parsing code, syntax parsing code for the DB2 version of SQL, where there were 10 identical comments mixed into the parsing code. That's, in software copyright, that is a big, big red flag. Because you can argue, efficiency, you can argue requirement, by outside stuff. In theory, if you're doing syntax for DB2, you're going to be doing the same syntax, but there's no excuse for having the identical comments embedded. Now, the advantage of Quest having come to me right off the bat, this was still in the early stages in doing this, was that they immediately set up a clean room reverse engineering team with Ed Jordan as the friend of mine, now deceased sadly, great software engineering author, as the expert there, and basically did a clean room re-engineering of that section of code with developers that they could certify had never seen the Perloin code. And they had that, by the time they got to one of their first hearings in front of the judge, they said, we've already fixed this, and sent out updates to everyone. Now, litigation still went forward for a while, and the 2 parties finally reached an agreement, but Quest came out far better than they would have otherwise, because they acted very quickly. Okay, lots of money at stake. I've done all 4 of these cases. In fact, I just got an email today on it, asking me about a new licensing case. Basic answer is, don't take stuff from your employer. I had another case where,
Did anything happen to the guy who took the source code in the first
I think they kept them employed until they settled the litigation. Then I think they probably fired the butts. But they couldn't afford to have them separate from them until the litigation was resolved. So, here's another case, software copyright I had. I was hired, again, in this case I was hired by the plaintiff. We said we had an employer or an employee who left. We think he took our source code and is using it because he's developing software that does what our software does. And so they gave me everything they'd gotten from him at Discovery. And I went through all the source code and I came back to my client and said, I'm really sorry, but their source code really is completely different. It's carrying out the same function. It's clearly different. I said, on the other hand, they have all sorts of copyright documents from you guys. Internal confidential documentation with your copyright notice on it that they've been using to develop this and they've been using in their marketing materials. So my client actually went after them for copyright infringement for the actual documentation, not for the source code itself. Patents, boy, patents are again, I could speak for about an hour on that. I've done several patent cases. Software patents are just a ball of worms. They really are. And I've done cases on both sides in software patents. In fact, have one that I'm working on right now, the gaming one I mentioned. And part of the problem there is that the federal courts, up to and including the Supreme Court, keep sort of giving mixed definitions of what's patentable and what isn't. And it shifts on almost an annual basis, if not more frequently than that. So, don't go where you're not supposed to. Don't take stuff. Non-work projects. A lot of you, how many of you have personal pet software projects you're working on? Okay? You have to be very careful about that. If you're going to work for a company, here's what you need to do. You need to disclose that up front. And you need to get in writing acknowledgement that they will make no claims on that work that you do at home. A lot of companies, if you don't read your employment, a lot of companies will have employment agreements. If you don't read it carefully, a lot of them will basically say, we own anything you do for the next. Yeah, for as long as you're working with us. I would strongly advise that you not do private projects that directly compete with your employer. You laugh, but it happens. It happens. If you have projects that you're really serious about continuing, get that down in writing with both parties signing off and acknowledging you're doing this and you're doing it on your own time with your own researchers. Never, and this would seem obvious, but I've had cases where this happened. Never, ever, ever use company time, company resources, company facilities to work on your private projects. Just don't. There's no good reason to. And don't walk off with anything from your company, unless you have actual written permission. And I say this as someone who, for the first several years, I was out in the industry, would commonly just take all the source code I'd written with me. If I thought it relevant, I could get a copy of it. That opens up a lot of real problems. Just don't do it. Any questions? Yes?
When you say to get both parties to sign off, would you just, like for me, would I just talk to a manager and say...
Talk to a manager and do this preferably before you get hired, but if you're already hired, sit down with them now and say, I'm working on this project, I would just like a little notice of memorandum that describes what I'm doing and that acknowledges that my work on my time is owned by me. Do that. We'll have 2 or 3 of those things that you're going to want to do when you get hired. Any other? Yes?
Out of curiosity, do GitHub licensing agreements change stuff like that?
I'm sorry, can you get?
GitHub licensing agreements? So I know some code, for example, some organizations put their code on GitHub.
Uh-huh.
Does the fact that they have licenses on there change the terms of
good question. I don't know. But that's probably something I should explore. If you're posting something on GitHub and your employer thinks you're doing it on their time, your employee may come back and say, we own whatever you posted there.
No, I meant, usually, I work for places that use GitHub.
Oh, for their own stuff.
Right, but they have licenses on the repo.
Then it's whatever the license is on a repo is what we're covering. In other words, if they're willing to put it up on GitHub, have it publicly visible or accessible, maybe not publicly, but it's accessible by that, then whatever license that chosen there is within the government's use. Because you will have organizations that will deliberately do open source stuff or generally make certain things visible. Yes?
Just a question about how far this extends. So if you're switching from one company to a very similar company, and you start using ideas of the next company that perform.
We're going to talk about that in just a second.
I'm not allowed to learn anything at these companies.
Non-compete restrictions. This is something that, again, if you're signing an employment contract, you want to see what non-compete restrictions there are. Because this is governed by state law and varies dramatically by state. So for example, in California, it is sort of a judicial matter of policy in the state of California that non-competes are largely unenforceable. This is actually part of why you have such a vibrant tech community there, precisely because people can go across to another company and take their expertise and work on directly competing products. Which we'll typically see is allegations by the theft of trade secrets, which gets us back to the intellectual property. And there's a whole body of law governing trade secrets, and or a violation of a non-disclosure agreement. Now, for other states, they can just, and this will give you a sense of how much it varies by state. The darker the green, the more restrictive it is. There are states where your employer can basically say, you can't work for any company that we deem a competitor for the next 5 years, and the state will enforce that. Yes?
What if you go to like work in a different state?
That depends on the state. Some states will say we will honor it. Other states will say we don't care. I know someone personally who worked for years in Wisconsin for a healthcare company. Moved here to Utah and knew that he was pretty much violating the non-compete that the first company had, but was trusting that they wouldn't care and they wouldn't try to have this educated here in Utah. But be aware, these are very real, and like I said, it's literally all over the map as to how they're enforced within the company. So if you're signing an employment agreement, look specifically about non-compete. Best thing to do, not legal advice, but practical advice, is to make them require an explicit list of excluded companies rather than a generic, anyone who's doing anything in this area. And as short a time frame as possible. Any other questions on this? Troubled or failed IT projects. There's a high rate of failure in IT projects, and by failure I mean going significantly over schedule and or over budget or never shipping at all. A topic of discussion throughout most of the semester. Some of you may find yourselves on those kinds of projects. Actually, I think a few you already have. And the question here is, why does it happen and what do you do? Now, you all know you just finished a midterm in which you discussed these issues, so I'm not going to spend a lot of time here. But these are things that you want to look for, and I'll post these slides along with the lecture, as danger signals. In other words, if you're in a project and you start to see these danger signals, there's a good chance it's going to turn into a jet march, or at least a seriously troubled project. And of course, that's when they come back and start asking for unpaid overtime and, you know, weekends and stuff like that. This is where, in my own experience, both as an employer and especially as a consultant, you want to raise issues early and often and put them in writing. Now, we're going to talk in a second about what you probably don't want to say. You know, there's a meme that goes around on a regular basis that says, you know, something like, you know, sing as if no one's listening to you, dance as if no one's watching, and write your emails as if they will be read aloud at your deposition. Truth. Because I can tell you, when I do a failed systems project as an expert witness, you know what I want to see? I want to see the emails from the engineers. Why? Because engineers are brutally honest and tend to be unrestrained. And I've done whole expert reports showing how badly the other side botched a software project, quoting only from their internal documents. I didn't have to quote anything on our side. All I had to do was sit here and go through memos and emails and say, you know, and they're saying this, and they're saying this, and this is what happened, they're saying this, and they're saying this. My first taste of that was one of my earliest cases, a failed software project. I was representing a client, which is American West Vacations. It had an outside consulting firm that was supposed to be developing a new vacation booking system. And there was this one engineer who was just totally frustrated with how bad the project was on the other side. And he had this email that said, I can't believe we're charging the customer $100,000 for this garbage we're delivering to them. It's kind of like, this is gold. You know, here, Your Honor, this is the whole thing. This is pretty much what we're saying. And the lawyers from the other side tried very hard to get, and there were about a dozen emails like that. They tried very hard to get him suppressed. The judge said, no, I'm not going to suppress him. At which point, case settled. Because they knew whatever they settled for was going to be better than what a jury would likely award them. So you guys should know all this stuff. This is what you've been studying all semester. Now, here's what you need to know. If it looks like there's litigation involved, you have a legal, and actually your employer, but it devolves upon you, have a legal obligation to preserve any relevant document. Litigation doesn't even have to have started. It just needs to be a possibility. Now, one of the things that actually, over 20 years of doing this expert witness work, has greatly encouraged my view of humanity, at least within the context of the U.S. legal system, is how many companies in this situation produce documents that are damning for their own situation, but they've actually preserved them and produced them. Even though, particularly with the explosion of electronic documents, there's a lot that they could probably delete without anyone knowing. Now, I can also tell you I've worked on cases where our side was pretty sure the other side had actually deleted documents wholesale. So it's not like everyone does this. But here's where it really gets into sort of your realm. There was a critical case. How many of you have ever heard of the drug fen-phen? It's a weight loss drug. American Home Products was producing it. Turns out that it caused pulmonary hypertension. And of course, there was a big class action lawsuit against American Home Products. And they were ordered to, preserve and produce documents. Under this, there's a rule in law called discovery, which is basically each side has to produce to the other side any potentially relevant documents, internal documents. That includes emails and memos and stuff like that. When I started my work 20 years ago, I used to get, I'd get like a dozen boxes of hard copy documents. Now I get hard drives. or there's online document databases. I've dealt with cases where there's over 1 million pages of documents. Unfortunately, they're all scanned and indexed so I can do searches, because there's no way I could ever deal with 1 million pages of documents. But at American Home Products, the problem they had is that they had, and this was about 20 years ago, pretty sure it was mid to late 90s. In their IT department, they had rotating backups on the tape for a 4-month period. I believe it was a 4-month period. So that at any given time, they had 4 months worth of backups of their computer systems, all the documents on them. And they would simply rotate through the 4 tapes. So at most, they only had 4 months. And they entered into litigation, and no one told the IT department to stop rotating the tapes. And so within 4 months, they had gone through and rotated through a lot, wiped out a lot of documents that you know, it deemed not to be preserved. What happened was the judge found out about that, and at trial gave the jury, told them they had to consider that spoliation, which is deliberate destruction of prejudicial documents. He said, you are to believe that whether or not they intended it, you are to judge this as if American Home Products deliberately destroyed harmful documents. And American Home Products lost and went bankrupt. So, yeah.
How does the preservation here, as far as you personally in the company, compete against the don't bring anything home?
Well, no, don't bring stuff home. In fact, that's a good way to follow it. Also, with a lot of companies, you'll find that they will have written policies, and this is why a lot, actually in the wake of American Home Products, a lot of companies establish written policies saying don't keep any emails older than 30 days. And part of what they would ask is don't take stuff home that has stuff that should have been deleted on a timely basis. In other words, they will establish policies to delete emails, and in some cases other documents, before there's any hint of litigation, so that if litigation starts up, there's only a minimal amount that's been preserved. And often the problem they'll have is you'll have people with, you know, desktop or laptops at home where they've been getting all their mail as well, and they'll have, you know, years of archived stuff. And they'll have to go through and ask the people to produce it. So, be sure your employer has written retention policies, find out what they are, figure them out, but if you find out your company's being sued, don't delete anything. Even if they come and tell you to delete stuff. Because that's pretty much how the Anderson consulting firm got destroyed. They were working with Enron. I assume all of you have heard at least the name Enron and Enron scandal. And Anderson Consulting was, not Anderson Consulting, but Arthur Anderson, at that time, one of the big 6 financial auditing firms. Their employees were shredding documents madly. And in fact, they found, you know, it was found out that they were shredding documents relevant to this lawsuit against Arthur Anderson. And quite literally, Arthur Anderson, as a financial auditing firm, was abolished as a result of what they did for destruction of documents. Any questions on this one? Yes?
Yeah, so like if the company comes to me and tells me to destroy stuff, why should I care what's going to happen?
Because you could be found, you know, you may find yourself a deposition. Them asking you, saying, were you instructed to destroy, to preserve documents or destroy documents? Now you may get off scot-free. You may get fired by the company because you then have the choice of either committing perjury or telling the truth and saying, yeah, they told me to destroy this. So, you know, that's the situation you may find yourself in. Any other comments or questions? Okay, so, and on top of all this, you have the simple truth that IT is a cutting edge of legal issues. I just was commenting on a post online as to why I am deeply skeptical of autonomous vehicles. For two reasons. One, as we've talked about here, it's really easy to get something to an 80% complete stage, and particularly under constrained circumstances. But stop and think of the moment-by-moment real-world decisions you make while you're driving. And with humans at the wheel, we still kill 30,000 people and injure 2 million people a year here in the US. What company do you think could withstand killing 10 people or 100 because of their software? Or crippling or injuring even just a few? You have the various, I mean, look at what an absolute mess security, particularly individual identity security is. It's like weekly, there's another large breach somewhere. I subscribe to one of the services that lets me know when my stuff is showing up, and I get probably about one email a month. Said, oh, by the way, this breach happened, and yeah, your name was in there. So it's, you want to be careful about what you do, want to be careful about what you consider. Get everything in writing with your employer. Make sure you've resolved these issues. Like I said, the big ones are going to be non-compete and any work you're doing for yourself on your own time. Get those in writing. Don't accept verbal assurances. Get it in writing. And if they don't want to put it in writing, that's a big red flag. Any company that really wants to honor that will gladly put it in writing. Say, yeah, we'll write this down. And any company says, oh, well, let's just shake hands. We'll just have an understanding that you can do this. And then, trust me, again, with 20 years of litigation support, I can't tell you how many times I've looked at my own client, or at least looked at the lawyers for my client, and said, why didn't they put that in writing? And the answer often is, well, we didn't want to show bad faith. Now, those are usually these are almost always two-party situations, but it's often employer complaint and so on. And I've seen so many cases where a simple document in writing would have stopped an entire lawsuit. And don't be foolish and walk off this stuff. I've done some of those cases. Just don't do it. However tempting it might be. Any other questions on any of this stuff? If not, okay, you do have a final podcast due this week and your number 9 status report. By next class, read Webster number 8. The lecture for that will be pretty short. But we'll have Crystal in here talking about what it's like to go from being a student to being a full-time employee. I will allow, if you have missed any podcasts or readings, you get 50% credit. DM me, Slack, let me know what you've done. I've updated all the scores I have to date, so it should give you a good idea of what your grades are looking like. In 2 weeks, we've got the in-class business pitch and the final demo. That's your final deadline for making up attendance by video, is basically class 2 weeks from now. So if there's any classes you missed. And I've updated attendance, so if you have 8 is a perfect score on attendance. 8 points, because that's 8% of your grade. So if you have anything less than 8, and you don't know what you missed, let me know, and I'll let you know. And you can already say, it's either say, well, no, I've already watched that video, or it's like, oops, I'll go watch that video. And then your last deliverable is due by the last day of the semester. It's set up as an exam. It's deliverable number 10 on lessons learned. And this doesn't have to be long. You can make it long if you want, but I'm looking for 2 or 3 paragraphs on the most important things that you learned in group projects. What were the biggest problems you had? what was the most important stuff you learned in the class, and particularly any suggestions you have for improvements in the class. So that's it. Like I said, the lecture a couple of weeks ago, and of course midterm, which y'all did great on midterm. What can I say? It's all downhill. No final. For those of you who still haven't heard me, all the times I've said that. No final paper. Just get caught up on stuff if you need to, and looking forward to your projects in a couple of weeks. Yes?
Do you have some kind of requirements or guidelines for the business pitch video?
Oh, no, just, you guys, what they used to do, what I used to do, what Chuck had them do, and what I did up until last semester was sort of, you didn't do a demo, you just came up and you did a video pitching it. That's actually more trouble than it's worth.
Oh, so no video?
No video, yeah, sorry. And there was, on the page, I know on the web page originally it said a video, I've changed it. No video. I mean, if you want to do a video, you can. But no video, no.
Do video.
I'll have you each come up as an entire team. You can designate who's going to speak, or one or more of you, and just give that elevator pitch. That here's why you should invest in this, or this is why this should be a success. This is why this is a great project. And then your last demo. So, we're looking at maybe 5 minutes roughly per team. If you want to go a little longer, but if you go more than 6 minutes, I'll cut you off. I'll have my little timer going again. So that's pretty much it. Other than that, finish your class. How many of you graduate this month? Congratulations. How many graduate in August? Okay. I was supposed to graduate in April and failed compiler building, so I graduated in August. Anyway. Actually, I was going to come back in September and take 431, which is compilers. Called the department. I was doing an internship at General Dynamics. Called the department and said, okay, I need to come back. And the secretary said, what? She knew me because I'd been a TA for years. I said, why are you coming back? I said, no, I have to take 431 for Bill Hayes. She said, wait a second. Went off and came back and said, I talked to Dr. Hayes. He said he's waiving the requirement. You can graduate. So I felt bad for years at not having ever finished. That was the hardest class. That had the highest failure rate in the class. Any other questions? If not,
Attendance.
Oh, attendance. Thank you.